Hello, guys. Today's discussion is around a very trending issue, but also very controversial. The question for today's discussion will be: can rape be charged together with murder? Now, the objective of this lesson is to throw some light on the controversy surrounding the death of a victim of rape or sexual penetration, as to whether the offender can be charged with both rape and murder. The starting point for a meaningful discussion around the subject matter should begin with a definition of key concept around the subject matter. One, the definition of rape, sexual penetration, and murder. Rape is defined in the Sexual Offense Act 2012, Section 6, as an intentional sexual penetration of another without the consent of the victim. Sexual penetration, according to Section 1, the interpretation section, is an act that causes the penetration of another in the vagina, anus, or mouth by the penis or any other object. It is a criminal offense to engage in such act pursuant to Section 19 of the same act. Murder, on the other hand, is an intentional killing that involves planning, premeditation to achieve a desired result, that is, the death of the victim. The death of the victim would be the desired result of a premeditated act that is done after planning. I will also add the definition of manslaughter because it will be useful at the end of this analysis. Now, there are two types of manslaughter. We have voluntary manslaughter and involuntary manslaughter. Voluntary manslaughter is a heat of passion, killing following provocation by the victim. Involuntary manslaughter is an unintentional killing that results from grossly negligent or reckless conduct regarding the life of the victim. Now, having said that, there are plethora of options open to the prosecution when faced with what charges can be leveled against the perpetrator depending on the circumstance at the time. For example, if the victim sustained injury while being raped, the offender may be charged with assault occasioning bodily harm plus rape. So the options are many, especially in an instance where there is rape and the victim didn't die. And even when the victim dies, there are other options as well as to what criminal offense can be charged. At this point, there is no way the offender will be charged with murder, as no death has resulted from the injury or encounter thereof. However, where the victim is killed immediately after she was raped, then there is also murder charge open to the prosecution. It is relatively easy to identify both crimes in this situation because in most rape cases, offenders may try to conceal their identity by getting rid of the victim to destroy all evidence. So mostly they do so by killing the victim. At this end, I would like to draw your attention to the earlier definition given about murder, that is, the specific intent to kill or to cause grievous bodily harm. So if we can deduce or discern a specific intent to kill by the perpetrator or to cause grievous bodily harm to the victim by the perpetrator, then the perpetrator can be charged for murder together with rape. The same would apply if the victim was seriously wounded and later died of her injury. Here, an intention to cause grievous bodily harm would suffice to establish that there was an intention to murder. The difficulty may arise when the victim sexually penetrated was a minor or raped in the case of an adult, and who may have later died from systemic internal disorder caused by the sexual penetration. This is in stark contrast with the offender who had deliberately or who had the specific intent to inflict physical injury or harm on the victim while being sexually penetrated. Now, in most cases, the prosecution will be cautious not to charge because of the difficulty in proving the specific intent to kill or cause grievous bodily harm. That doesn't take the defendant off the hook immediately. If the defendant cannot be charged for murder in an instance where the victim later dies of an internal injury that was sustained while she was being raped. Now, it is important to note at this point the offender or the perpetrator had no specific intent or did not deliberately plan to kill the victim. So, sexual penetration of a minor is grossly negligent or reckless conduct endangering the life of the victim. Suffice to say, an involuntary manslaughter. Thank you for listening. Hope this session was educative.